Welcome to today's Openroom University course. We're diving into the next step for Ontario landlords who have already secured a judgment. How do you actually collect the money owed through a garnishment? I'm Wei-Ting Bolu, co-founder of Openroom.ca. At Openroom, we aggregate tenancy court orders across Canada and make them searchable so you can understand how residential tenancy disputes are being resolved. We also help hold people accountable by reporting rent payments or unpaid rent to impact credit histories. As of May 2025, unpaid rent in Ontario has reached over $287 million. This is just based on over 40,000 Landlord and Tenant Board tribunal orders tracked by our team at Openroom.ca. Getting a judgment is one thing, collecting on it is another. Let me tell you, this is not easy. To help guide us through the garnishment process, I've invited back Jordan Nieuwhof. Jordan is a former licensed paralegal in Ontario who has helped thousands of landlords and tenants navigate the legal system. He now shares his knowledge to empower landlords to make and take action with confidence. In this session, Jordan explains when it makes sense to pursue garnishment through an employer versus a bank, how the process works, what legal limits and timelines you need to know, and how to properly complete and serve the required forms and affidavits. He'll also walk through withholding periods, but most importantly, when you can actually expect to receive the money. If you've ever struggled to collect on a judgment, this session is for you. We'll get started right after a message from our sponsor. As a landlord, making your properties stand out to renters is more important than ever. That's why Rentals.ca offers verified listings, a free service that confirms your identity through Persona, a trusted third-party verification provider. Verified landlords get a badge on their listings, instant posting, and up to 3 times more leads than non-verified listings. With thousands of renters searching daily, getting verified makes your property stand out as a trusted listing that gives renters peace of mind. Get verified and list for free today on Rentals.ca.
So, understanding the garnishment process. So, this is after you get that LTB order. In many cases, it's after the tenant's also evicted, but on an L9, that's not necessarily the case. What you need, though, to start the garnishment process is an order advising you how much the tenant owes you. And that can be dependent on whether or not the tenant is evicted. Now, if there is an eviction order, what I would highly recommend is you wait. I know it's exciting to get to the garnishment process, but if you can wait, because there's a per diem that you have to calculate on the garnishment process itself to the total amount of damages that are owed. You can bypass this and just go ahead right to the filing. If you're going to do that, I would suggest getting some legal advice on how to fill out the form. But in most cases, I suggest to the landlord, wait until everything is calculated, unless there's some certain circumstances, like you don't know where the tenant is moving to, but you know where they work. Then you may want to just rush the process as soon as you get the order to file the garnishment. But in most cases, what we need is a total amount of money that the tenant owes you up until the point that they moved out by either voluntary effort or by sheriff's eviction. And that amount is calculated for the garnishment right up to that point, even beyond what the order says. Let's say the order says that the tenant owes $10,000 in rent. All right. So the board has found that the tenant owes $10,000 in rent, but there's a per diem of $100 a day for every day that the tenant is in past the termination date. Well, that $100 a day, that's the per diem amount. You get to add it on top of that $10,000 when filing your garnishment. So let's say they didn't move out for an additional 10 days and the sheriff acted in a miracle and they evicted the tenant in 10 days. So there's an extra $1,000 is owed. You would take the $10,000 from the order plus the per diem of the $1,000 to get to a total of $11,000 owed. And what you're going to want to do is write this out on a word sheet, which is in addition to your garnishment paper or your Form 20P. And that's just a list of calculations. And the Form 20P actually asks the list of calculations itself. So on a beautiful word, you'll just write out and explain how you got to your total number. So, simple. What is a garnishment? 2 popular kinds, a wage garnishment and a bank garnishment. The wage garnishment is the most popular garnishment out there. And that is when you're going to go to the tenant's place of employment and you're going to garnish their employer, and their employer, if they're an honest and good employer, is going to take the sum of money that would have otherwise went to the tenant and they're going to deposit it into the courthouse. And then the courthouse is going to hold it for 30 days and then release you a check from the Minister of Finance that you get to go to the bank in cash. The other type of garnishment is where you're actually garnishing everything in the bank account. So they will pull everything up to the amount of money that is owed. As long as it's in the bank account itself, they'll pull it. The reason it's not as popular is because many landlords don't know where the tenant banks, and garnishments are specific. It's not enough to say, oh, the tenant banks at RBC, so I'm going to garnish RBC. Unfortunately, the banks work against you. And what the bank needs to successfully do a garnishment is not the account numbers, but where the actual branch is. So let's say St. Catharines, for example, and they have 7 RBC bank accounts. And this just is an RBC, it's actually for all banks. They all require which bank. And you have to serve the proper bank. So is it the bank on Grantham Avenue? Is it a bank on Scott Street? Is it a bank in Arrowdale? You need to know where the tenant banks, not just what bank they bank with. And that can be a little bit tricky. The nice thing is, and the best thing about a check, is if you've ever had a check deposited, the bank can distinguish where that's from transit and routing numbers. They can go, oh yeah, this bank was deposited at Scottdale RBC. One of the things that I like to do is if you do, for whatever reason, rarely, but let's say you do owe some money back to the tenant, do it in a check. They're going to take that check down and they're going to deposit it into a bank. And when they deposit it into a bank, you're going to know where they deposited so you can do some garnishments. So that interest that you're ultimately says the tenant's owed, a few dollars out of pocket, you could technically send them an interest payment check. This is the interest as per the order I owe you. They go ahead and they cash it in the bank and they can garnish them for the principal rent that you're owed. Some other things you can do, there are some paralegals out there and some PI companies that will actually issue a refund check to the tenant in an Ontario corporation number, white check, just like the government gave you a white check recently for the $200 that you take and cash it into a bank account. Tenants will often take, $35, $40 check, whatever it's from. It says refund check. They'll put it in the bank. When they put it in the bank, the routing and checking number that you can later follow up and garnish. Checks are beautiful for that reason. I know we don't use them nowadays, but write it down that you can issue a check to the tenant or have a third party issue a check to a tenant. And if they happen to take that check and cash it, you know where their bank account is, or you have the ability to find out where their bank account is. So then you can garnish the money. That solves problem one. Problem two is the tenants actually got to have money in that bank account you're garnishing. And oftentimes they don't, or they don't have a lot. But ideally, the most successful people that garnish wages, especially from tenants, are strategic when they issue your garnishment, when the bank processes the garnishment. And that's generally a couple of days before their assumingly rent that they're going to pay is due. So when you're garnishing a tenant and you happen to know where they're going to bank, are you going to issue and serve the garnishment on the 15th of the month? You can. Legally, you can. That's most likely where they're going to have the lowest amount of money, though. You want to time this strategically to when they're going to have the most amount of money. And it's a bit of a guessing game because the bank actually has to go in and through the process to actually go ahead and take the money from the account and apply the freeze. It can happen within hours. It can take a few days, sometimes a week. So you want to be strategic. And there's no right answer. Like you could go to the bank on the 30th of the month, or the last day of the month, and go garnish this. And the bank might not get to it until the second or third. Well, the rent's already been gone. The counts are low. It's unfortunate. But ideally, you're going to try to aim around the end of the month when the tenant's most likely to have enough money to send the next landlord some sort of rent payment. All right, so garnishments are strategic. Now, filing the garnishment, you have to take that into consideration as well for timing, not just serving it, but also when you go ahead and file it with the court. If you take it down to the courthouse, they're most likely going to give it back to you the same day. You're going to pay the fee by debit or cash or whatever it is. If it's a check, it's made out to the Minister of Finance. And then they're going to stamp it and they're going to return to you the garnishment paper. If you file it online, come back the same day, come back a couple days from now, or whatever. There's no guarantee. If you're eager about filing the garnishment, the best course of action may actually be taking it down unless you plan proactively ahead of time. Let's say you're not going to do this till the end of the month and it's the 5th now. Go ahead and file it online because it doesn't matter if it takes a week to get it back. You're going to strategically serve it closer to the end of the month, anyways. So there's lots of time to play here of when to successfully do a bank garnishment versus a wage garnishment. Wage garnishment, you serve it and you hope that the employer then does their duties to issue the money to the court. Bank garnishment, play on strategic timing, not necessarily because I want to do it now. Strategy. All right. So, of course, what are you going to do? What you need to garnishment and actually file a garnishment is you need an order. I think that's very clear. You need an order from the courts or from the tribunal. Now, what a lot of people do and when they make a mistake in is they take their LTB order and they say, I need to collect in small claims court. And they get this thing called a plaintiff's claim or a Form 7A and they've paid $102, $103. It's the wrong form. You do not need to sue your tenant in small claims court and repeat the process and go in front of the judge again. That is a myth, a big myth that has cost a lot of landlords a lot of money, made the government a lot of money because once you get to a settlement conference, the judge goes, you can't go any further, and I don't know why you're here. Go down to the counter and get the right paperwork. They don't give you a refund. So the government's making a lot of money on this. It's costing landlords a lot of money because they don't know the process. They think that they need to sue the tenant again in small claims court. That is not true. You go from LTB order directly to garnishment. And all that you have to do is pay a small $42, it might be $46 now, fee to get a certificate of judgment. Then go ahead and start the garnishment process. And that happens at the same time you're filing your garnishment paper. So if you see a 7A, or if you have a 7A you're about to fill out right now, and you already got an LTB order, you take that 7A and you put it in the recycling bin, and you certainly don't go ahead and pay for it at the court. If you've just issued a Form 7A, it's unfortunate. You've lost your money, but also shred that form because you don't need it either. You need a certificate of judgment and the garnishment. You already have the LTB order. You don't need to go to small claims court to sue the tenant again. You get to bypass all of that. You're actually dealing with the same department that processes the eviction orders. It's the sheriff that's going to do the wage garnishment. It's the sheriff that's going to do the bank garnishment. It's the sheriff that's processing the paper on behalf of the small claims court. So you're actually not technically even dealing with the small claims court. You're technically dealing with the sheriff's office that acts for all enforcement matters, including garnishments, examination hearings, writ of seizure of personal property, writ of seizure and sale of land. All of these enforcement things are all through the sheriff's office. They just happen to be handled by the small claims court. Small claims court handles plaintiff's claims defenses and stuff like that, stuff that you don't need. So if you got a 7A, scrap it now. If you're looking at doing a 7A, scrap it. You've already got an LTB order. You're doing a garnishment. You're doing an enforcement process. You don't need to sue again. So we've already talked again about garnishments, garnish wages, garnish bank accounts. But what about other forms of what I can garnish? You hear that I can't garnish disability payments. That's true. You can't garnish disability payments from ODSP and welfare checks and government support and stuff like that. But if the tenant says, oh, I'm on disability, is it WSIB? If it's insurance or WSIB or other benefit intended to replace wages, that's up for garnishment. And you can actually find that under the Wages Act, Section 7. You are permitted to garnish things like WSIB and private insurance replacements because they're meant to replace a wage. So when the tenant says, I'm on disability, well, what kind of disability? Is it ODSP or is it insurance disability intended as the wage replacement? That is still garnishable. And that you need to know. ODSP, hands off. Wage replacement insurance, you grab it, you garnish that. It's important. So again, we've talked about the garnishment types quite a few different times. So is there A legal limit on garnishments? Yes, the Wages Act. 80% of garnishments in the Wages Act is exempt from seizure. If it's for spousal, we're not spousal here, but it's down to 50%. Unfortunately, you are a creditor and the debtor under the Wages Act is 80% exempt, which means you can only garnish 20% of those earnings of the gross pay. So keep that in mind. And unfortunately, the court can vary that too. So if the tenant takes you to a garnishment hearing, says, I can't afford the 20% wage garnishment, the court, unlikely and most likely not, but the court does have the authority to vary that. Do they? Sometimes. Unlike the board, the court, the tenant needs a lot of proof to reason why they need a different amount garnished, but for your purposes, it's 20%. You can garnish 20% of the wage and 80% of the wage is exempt because you're a standard creditor. All right. So what is the impact on the debtor? Well, the debtor is going to have to pay you and some money comes off of the wages. It doesn't have that big of an impact, unfortunately. What does have a major impact isn't just stopping at the garnishment process, but also taking that order and filing through programs like Openroom to get this publicized on their credit reports. And this is one of the biggest things that collection agencies actually do in their trick in collecting debt. It's not going to court and going through garnishment wages and stuff like that. It's taking the debt and reporting it to the bureau. Why? Because when your court debt is reported to the bureau, they're not getting financing, not getting mortgages, not getting car payments, sometimes not even getting student loans, not getting credit cards, not getting any finance products. Or if the lender is going to give them a financial product, it's at such ludicrous interest rates. It does have a damaging effect on credit. And this is why you'll often see in screening a tenant has a super high credit score but hasn't paid their debt because not every landlord is reporting rental debt to the credit bureaus. And it's paying a huge impact on determining or the tenant's determination of what debt to pay. If I was a tenant in arrears, I would pay my car loan, my credit cards, my cell phone, and everything else that may report to the credit bureau before I pay my rent. Why? Well, my landlord isn't reporting me to rent. I can therefore move somewhere else. I got great credit. Change that. Change that behavior by reporting the rent to the credit bureau. You don't need an order yet. You can report late payment. Some places do require, however, proof, specifically that order to be able to post to credit bureaus. But technically speaking, the law allows you to report delinquent payments to the credit bureau without the tenant's permission and without a court order. You do have to be careful of libel and slander. But again, what is powerful is that ability to report that debt to the credit bureaus to get payments, to prevent further lending products being given to the tenant. These are all tools, just like the garnishment is a tool, an examination and hearing is a tool. You have to utilize all your tools to collect from the tenant. And sometimes the tenant doesn't have any money to pay right now. Does that mean now you give up and say life move on? No, you continue the pursuit. You report it. It's going to affect their credit for a good 6 to 7 years. Impact on the debtor. Yeah, the garnishment doesn't have a big impact on the debtor, but the other tools like the examination hearing and most importantly, debt reporting is going to have a major impact on the tenant. What does getting a credit report sometimes do? Well, in addition to harming their credit score, if you can get that credit report, it'll sometimes show their new place of employment. So if you don't know where they work right now, and let's say that they went to apply for somewhere, the bank loan, the credit card, the vehicle, electricity, wherever they are, often going to have a question of where do you work? And that in many cases gets reported to the credit bureau, which then when you get that report, you can see their new place of employment. It's not perfect, but it can be a great tool in distinguishing where the debtor works. So then you can go ahead and garnish. All right. Process of the garnishment we touched upon a little bit here. You're going to file the proper paperwork, avoiding the Form 7A. That's the plaintiff's claim. They're going to issue back a garnishment. You're going to serve it. But one thing we didn't talk about is who to serve. Yes, you need to serve the bank or the employer or whoever you're looking to garnish. And then you need to also serve the debtor. What if you don't know where they work? This is an unfortunate thing that stops a lot of landlords from being able to garnish a bank account and or an employer. You don't know where they are to serve them. Does that mean you need their home address? No. If you know where they work, you know where they're going to be in most cases, you can serve them there. So just because you don't know their home address doesn't mean you can't do the garnishment process. Yes, you need to be able to serve them, but you can in fact go to their work and serve them. That's where they are. Go serve them there. You don't need to know where their home address is. If it's a bank garnishment, you don't know where they are, that can be a little more challenging. Technically, it's not right. But some landlords have put on the tenant's old address and got it through and got the garnishment processed and then mailed it to their own address. Is it right? Is it wrong? Let's not comment on what is right or what is wrong right now. Let's look at what the tenant is supposed to do. The tenant is an adult. The tenant is responsible. For all you know, the responsible tenant has changed their mind and has now become responsible and has paid for Canada Post mail forwarding, and they're still getting the mail, or they have made some sort of arrangement to collect their mail at your old rental unit, at your old address. You don't know that. Is it proper? Is it not? Are you going to try it? It's not legal advice, but some landlords I've seen on Solo and I've seen it myself have had success putting the old address on the garnishment form, getting it processed by the courts, and then serving them by mail at the old address. Well, they're going to get it when they get the wage garnishment, anyways. If they want to contest it, they're going to ask their employer, the bank, hey, where's my money? And the bank's going to go, oh, it's been garnished, go down to the courthouse. Then they can go ahead and file a garnishment hearing. Is it proper? Is it legal advice? No, 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 not legal advice. I'm just saying, some people have had success doing it. Up to you if you want to do that or not. But if it was my money, I know what I would do. That's part of the process of the garnishment there. Do you have to defend against a garnishment? Well, the debtor, just like you're going through the process of eviction, has the right to respond. And what does that mean? They can file a garnishment hearing and they can say, it can't get garnished. This isn't the LTB court anymore. This is in front of a real judge or a deputy judge at the small claims court that's following some very different rules than at the LTB. They are following rules of the law, and they often make some very decent judgments. And when a tenant comes in and says, it can't pay it, first thing the judge is going to ask is for proof. Why can't you pay it? And they better have some proof. This isn't like the board where they can just go, I can't pay it because of, and list 500 diseases that they apparently have, but have never been to the doctor and they get to stay. No, this is much different. This is, I want to see the proof. And the judge will. The judge is not afraid to go, you know what? I'm going to hold the garnishment where it is. I'm going to adjourn this, and you come back with proof. They better come back with that proof because they're not going to get in front of the judge again without proof. Now, what happens if the tenant does come up with the proof? Maybe the garnishment gets reduced from 20% to 10% for a period of time. It's unlikely, though, that the judge is going to cancel the garnishment out altogether. He recognizes that this is a debt and that this is a legal process that you're entitled to get paid. So can he vary the amount? Yes, he can. I don't see it happen too often. But is he going to say, no, you're entitled to nothing? No, most likely not. This isn't the board. This is a judge who sees the law in a very different context than an LTB adjudicator. And this judge is going to want to see the proof, and he's going to want to know if he's going to vary it, a darn good reason to vary it, and for how long and why. Then you know what? Maybe it drops a little bit. Not the end of the world. You're still getting paid. Judge can also do the opposite as well and say no, keeping it as it is. Again, it's up to the judge, but it's up to the defendant, or in this case, the debtor's circumstances with a lot of proof. So I wouldn't be so terrified of if a debtor defending a garnishment hearing. Would I run out and get a legal representative for this? It's your choice, really, truly your choice. I don't know if I would spend the money at a debtor's hearing with a legal representative if it was a clear-cut case. If there was a bunch of allegations against me, maybe I would. But again, does it hurt to get a consult? No, absolutely get a consult. You need to spend the money on legal defense on this? Maybe not. Probably not. But again, you'd consider that as those circumstances arise, and they don't happen very often. All right. Are there some restrictions? Yes, there are, and we have went over a lot of restrictions, but there are some very unique restrictions like tools of the trades, vehicles, stuff like that in different enforcements that are just off, that you just cannot. You can go over these at your own leisure because we're going to be sending these slides out. But ultimately, the biggest one, remember, 80% of wages are in fact exempt from garnishment. And bank accounts, if it's co-owned, can have some restrictions on it as well. Overall, if you're doing a garnishment, wage garnishment, you're going to get 20%. Not a lot of other major restrictions on garnishment, but there are a lot of restrictions on some other enforcement aspects. So, what information for the garnishment? We've went over this. The employer information. And, well, let's go over this really quickly here for a second. Is it proper to say that they work on McDonald's and write down McDonald's on the sheet and send it out? Well, possibly, but most likely not. It's then up to the employer to make a decision of whether or not they're going to if they're going to honor that garnishment. And why? Because you have to name the entity properly. If they're working for McDonald's, they most likely have a corporate number. That corporate number should go down on that sheet. It's really important you get the legal entity right. You can't just put down Walmart. Well, again, you could. Would a big corporation argue it? Maybe not. Most likely not. There's been a lot of successful landlords that have garnished with just writing down Subway and serving it on Subway where they work, and the garnishment has gone through. Does that mean it's proper? No. Does that mean they can ignore it? Yes. Should they ignore it? Morally, no. Legally, they can. So what should you do? Run a nuance search. Get the corporate number. Then put, you know, numbered company Ontario Inc. operating as Subway. There you go. Now, if they don't pay it, you have some really cool rules we'll talk about shortly. But for the garnishment itself, it's just important that you get the legal entity when you're garnishing an employer. What if they're a sole proprietor? It is possible that they are a sole proprietor, so you'd put their legal name, DBA or COB. DBA means doing business as, COB means carrying on business, and then the name. So, John Smith carrying on business as John Smith's painting. Legal entity, serve the garnishment for the employee. Hopefully they comply. But if they don't comply, again, you have some really cool rules we'll talk about shortly. So, it's important you name the party right. Subway doesn't do it. Walmart doesn't do it. Go the further extra step, get the nuance report, and list the Ontario Corporation number or the Canada Corporation number to better protect you if the garnishment starts to go sideways. See? Corporate search. And then you need to know the right address. That's important as well. You need to know the address of the employer. You need to know the address of the bank. Get the right address. Some employers will play games like, oh, you can't serve it on me. You have to serve it at head office. I've seen that before. And when I process garnishments, I've had that before. It's like, okay, no, thank you, though. I'm serving it on you. And now I'm also serving it on head office. I make sure that they both get paperwork. I don't like playing games. They could easily send it to head office, but that's the establishment. That's where they're paid. That's most likely where payroll is running out of. You're getting it, and now head office is getting it. They're both getting it. They're both going on the affidavit of service. They're both being filed. Simple as that. Not playing games. Let them figure it out in court later. Moving on. Yes, there are some forms. You need the Form 20P. That's your affidavit of enforcement request. This is important to processing a garnishment. It's called Form 20P. You get it from Ontario Court Forms. Write this number down. 20P. Affidavit of enforcement request. You need it. If you don't want to go to Ontario Court Forms, go down to the courthouse, ask for Form 20P. They'll give it to you. You can fill it out on paper. And then you need this fancy form, the notice of garnishment itself, Form 20E. Write that down. Again, if you're going to Ontario Court Forms, Form 20E. Otherwise, you can go and get it from the courthouse. And then you need this fancy thing called a Form 20F that you don't do with it, but you have to serve it on the garnisher. And that is the garnishee statement. And it's their obligation to fill it out when they're sending money to the court. What is important with these forms, and especially on the Form 20E, You can get the courthouse and the file number correct. So yes, I said you can serve it blank, but I like to fill out for them the court number, the file number, and the court information because I actually want the garnishee, the person that's going to be giving me money. I want to make their job as easy as possible. So I'm going to fill out the basics on the form so that they can just file it with the courthouse with the money that they're remitting. Make their life easy. Most likely they will comply. Not to mention, let's say they don't write down the court file number, they write down the wrong court file number and they send it to the courthouse. Where's your garnishment paperwork going? Could be processed in the wrong file, and then it has to be sorted out later. So do yourself a favor and fill out the information for the courthouse and the file number when you're serving the garnishee so that when they send that to the court with the payment, there's no errors on it. You know that it's correct. You're not leaving it up to the garnishee whose employee on Friday afternoon is scribbling down some scritch and scratch because they want to get out of there, sending it to the courthouse, and your payment's being directed to someone else. Let's make it easy. Fill out as much as you can on the garnishee statement to make it easy for the garnishee to submit money to the court. So that's it. 3 forms: 20P, 20E, 20F. And then, of course, your certificate of judgment, which is just a payment, not a form you complete. You're just paying that $42, $46 to the courthouse. They'll give you back a piece of paper, which they don't even do anymore. They just say, yes, it's now registered. But for you, 20P, 20E, 20F, 3 forms for garnishment, not complicated forms, and you can fill them out. All right. Then we talked about service and what we need to serve. We need to serve the garnishee, the 20P, the 20E, the 20F, and then we need to serve the person we're garnishing, or sorry, the debtor. We need to serve them the 20P and the 20E by mail, regular mail. That's it. And then it's important you take the affidavits of service because you have to complete affidavits of service, both of them, and file them with the courthouse. If filing them online, you need to find an independent commissioner. I can commission them for you and go ahead and file online. If taking them down to the courthouse, they'll commission them for you and file them. But if you do not file the affidavits of service, that money will sit in the court's trust fund and sit and sit and sit. And months later, why didn't I get paid? We call the court and they're going to say, well, we're missing this. It's important you do it. And if you don't do it right away and forget the date you served, that's going to cause a whole lot of problems. So get the affidavit done right away. That's the 8A. That's the affidavit of service, Form 8A. Fill it out, get it commissioned, file it with the court. You're in good shape for when the garnishee sends in some money. Then after the holding period, it'll be released to you.
Jordan, we
Yes.
are at 8:31, so it is time, but let's go through a few more things for those who want to stay. If you cannot stay, feel free to drop and we will send out the recording a little bit later on in the next month, okay? And then I know that there are also questions, but of course, Jordan and I are staying online until midnight. No, I'm just kidding. We'll be here and we'll continue a little bit further, okay? Because there's some really good information here.
Okay, let's go just 2 seconds here on, I think what is the coolest part about a garnishment at all for everyone to hear is what the heck happens if you have served a garnishment properly and everything's absolutely perfect and the bank or Walmart or the employer or Subway, whatever employer you have says, yeah, we don't believe in it. Well, you can file a garnishment hearing and actually get an order that says they owe the money now. So if you have a small employer that says, I'm not sending the money in, you can get an order directly against the person you are intending to garnish. You don't even need to collect the money from the debtor anymore. You now have a bank you can collect from. You have an employer you can collect from. So these have serious consequences. And if you know that the person is working there and somebody's trying to pull a shady or ignore it, you can actually file a garnishment hearing against the garnishee and get the court to change that order that says they also owe the money. And then you can enforce directly against them through banks and garnishments and stuff like that. So really powerful tool you all need to be aware of. If the person that you're garnishing ignores the notice, you can get a personal judgment against them as well. And now you can garnish their bank account or whatever it may need to be. And this is super cool if the tenant that you're ultimately garnishing also has a corporation, and you know that that corporation has a bunch of assets, money, fees of processing, stuff like that. If they're ignoring it, you can get an order against their personal corporation or their professional corporation, and then start to garnish things like processing payments, bank accounts, Visa, any way that they get money in, you can start taking. There you go. Really cool part about the garnishment process that many people don't know about.
Jordan, were you going to continue on to a couple other components, or that was the mic drop you want to end off on tonight?
Well, we could certainly go over a few other components of it. An interesting thing is what happens if there's a co-own or co-debt or the bank accounts owned jointly. The co-owner of the debt, unfortunately, or the bank account or whatever it is, they have the right to unfortunately also file for a garnishment. So let's say that it doesn't happen very often, but let's say there's a joint bank account of somebody else, a spouse or something like that, that doesn't owe any money to you, and there's money in that joint account, they can file a dispute. And if they can prove a certain amount in that account is theirs, it most likely will be exempt from a garnishment seizure. Doesn't happen too often, but you do need to be aware about it, that anybody interested in this garnishment can file against you. Again, it doesn't happen very often, but any interested party can file a garnishment hearing against you. There are, however, some timeframes.
So, what happens after you do affidavit of service?
Well, after the affidavit of service is completed, you file it with the courthouse, right? And then once the document or the affidavit of service is effectively filed with the courthouse, there's a holding period of 30 days in which that's the holding period for which no money can be released. So even if the bank or the employer sends the money to the courthouse, you cannot get it for a period of 30 days because the debtor or a co-owner of a debt or any interested party actually has the right to file a garnishment hearing to then decide if the fund should be paid out or directed or otherwise. So there is that 30-day holding period. If upon the funds are paid into court, 30 days pass
Jordan?
and there's no garnishment
Jordan,
hearings.
go to your
Yeah.
next slides. Your next slides talk about each of these.
Yeah. That's the filing of the affidavit of service. Once the affidavit of service again is filed with the courts, the funds are held for a period of 30 days once they're paid in. And once those garnishment funds are in fact paid in, meaning that they're held for 30 days, it allows the debtor or anybody essentially who has an interest in the garnishment to file with the courts to dispute it to make a determination on the funds. But it rarely happens. It rarely ever happens. More often than not, it's that the actual person that's being garnished, in this case would be the tenant or the defendant, who's saying I can't afford 20% garnishment and they're looking to vary it. That's more likely what happens than an actual third party coming in and contesting the garnishment itself. So that's what happens when you file the affidavit of service. It proves it was served and it triggers a process with the courthouse to hold the funds and then release after 30 days. And that's the initial holding period we were just talking about for the 30 days. See? The clerk holds the first payment for 30 days. And it's not every payment actually that's held for 30 days. It's essentially the first payment that's held, and then every payment after that is processed by the courts and it's sent out. Unfortunately, there's oftentimes a major delay, especially even with the courts today, from when it's paid in to after the 30 days to when they've actually cut you that check. And it can be several months. So you call the courts and they say, yes, funds are in, and then it's waiting to be processed. Several months later, you'll get some text from the Minister of Finance, and then ongoing from there after until which time the garnishment is paid in full, or there's no more garnishment money to be paid because the person quit their job, or there's no money in the bank account. No, happens. And then, yes, the distribution of funds. This one's interesting. So, how are the funds distributed? If there are more than one garnishment, so let's say a credit card company is garnishing or another landlord is garnishing, the funds are distributed to the garnishees equally. So it happens every once in a while where one landlord may be garnishing and another landlord has a garnishment in. And it's not like they're taking 20% of the wages and then another 20% of the wages. No, it's 120% of the wages that's coming off. And then the funds are divided equally among everybody who has a garnishment right at the courthouse. And that's same with a bank account. So the funds are distributed equally to everyone who has an appropriate garnishment at the courthouse itself. So that's how the funds are paid out or distributed when more than one garnishment is there. Doesn't happen too often, but every once in a while, a landlord will already have a garnishment out. A tenant didn't pay their rent, and there's another garnishment out. And then what you'll have is a distribution of the funds. Again, not common, but sometimes does happen. And then, yes, okay. So again, this goes with all creditors and any subsequent garnishments that come in. So you've got a garnishment now, there's already one before you, and then the tenant went and screwed another landlord and they get a garnishment out. Now it's divided three ways. So it just continues down until finally someone's paid off. For the payouts. This is what we're talking about with the hearings. The judge has the right to vary how much is paid in or paid out, and as well as who's getting paid. If there are more than one landlord, it's the landlord files the garnishment, but there may be additional creditors. So those payments can also be distributed out and spread out. Oftentimes, it's just husband, wife that owns the property, single landlord, but sometimes it's two business partners. If you're both lifted on the garnishment, funds are generally spread out among the creditors and the additional creditors, but sometimes it's just paid to one, and then it would be a dispute between the two business partners how those funds are distributed. So if you have multiple creditors on your Form 1A as part of your garnishment process, those funds are often distributed out to the creditors, and sometimes the courts do just send it out to one creditor on that list. So that's essentially how those payments are paid out. And again, the judge has the right to vary the payments and even shrink the garnishment if they feel it's fair and necessary. Doesn't happen too often. So the sheriff. Yes, sheriff demands funds. That's who's essentially going over the enforcement process for the garnishment. Again, as we talked about, small claims court handles the paperwork, but ultimately this comes from the sheriff. It's the sheriff's direction to have funds paid into the courthouse. Ultimately, it's the bank or the employer, whoever you're garnishing, to enforce that. And then if there's a failure, you can go through another step. So let's say the employer was to be sending out wages or the wage garnishment and they fail, you can go to court. All of a sudden, the employer themselves are responsible for the debt, no longer the original person you were garnishing because the employer failed to do their duties to submit money to the court. You can get a judgment against them. And then you can go ahead and issue a garnishment. And if that doesn't work, you can do another form, actually start seizing assets of that employer. What we call a till seizure, because the sheriff would actually used to go in and seize the tills. You can still technically do this today. You can hire the sheriff to go in and seize the property of the employer to pay off the debts. And this can be in form of a till seizure or other methods. It's a little bit different from the garnishment, but in many cases, you start with the garnishment, and then if the employer or the bank fails, you get a judgment against them, and then you look at the next steps, such as that till seizure, seizure and sale of personal property. All right. Court orders and delays we've talked about. We know that the courts can vary, and we also know that there's unfortunate delays from the time the process starts to when you're actually going to see those funds from the Minister of Finance. So again, the process isn't quick. There can be several delays that happen primarily due to the court speed. A backlog because of COVID still persists even today. All right, bankruptcies proceedings. So unfortunately, if a tenant, after you filed a garnishment, goes bankrupt, there's a stay on the proceedings. You're not going to get any further money. It's going to be handled by the bankruptcy trustee. And then what you're going to be is you're going to be notified by the bankruptcy trustee, and they have a process to follow to liquidate the estate and any assets that may be there, and you'll be entitled with all the other creditors what assets are left. But your garnishment itself, if the tenant files bankruptcy, is stayed and everything goes through the bankruptcy trustee. How do you know if the tenant filed bankruptcy when you're at the garnishment stage? Well, the funds will stop rolling in and you'll get a letter from the bankruptcy trustee advising that your tenant, or what we're going to call a debtor, has filed bankruptcy, and there'll be a method to contact and how the assets are being liquidated and what you may or may not be entitled to. But again, if the tenant goes bankrupt, there's a stay on your garnishment. It's just stayed and the debt most likely gets wiped out. You'll handle that with the bankruptcy trustee. If, let's say, the tenant hasn't gone bankrupt yet and they're threatening to go bankrupt, does that mean you shouldn't proceed with the garnishment? Well, in my experience, tenants have threatened bankruptcy over and over again, and very few of them actually go through with the bankruptcy. It sometimes happens. I've seen it more often today than any other time in the last 10 years, but it's still a rather rare event. If a tenant is threatening that they're going to go bankruptcy and you have no evidence that they've gone bankrupt before, file your garnishment. If there is some evidence that the tenant has gone bankrupt before, does that mean you shouldn't do it? No, you should still go ahead, file your garnishment. Maybe hopefully you'll get a few dollars before they actually do go ahead and file bankruptcy, but just be aware there will be a stay. Now you can always do a bankruptcy search. Gonna put the links in below. Does cost some money, but you can find out if your tenant's gone bankrupt before or if they're currently in a proceeding of bankruptcy through a bankruptcy search through the government. And we'll put the link in, of course, here. All right. So appeals, yes, everything can get appealed. It can delay the process. We're not going to get into it here for this portion. Just know that if there's a garnishment hearing and there is a dispute on it, yes, things can go and they can get appealed, and that can delay the process. All right. Limitation periods for notice of garnishments. There are limitation periods, and you have to know that there are limitation periods and how long you can act, and that is 6 years. Does that mean that your debt's abolished after 6 years and there's nothing you can do? No, actually. What the limitation period essentially is it means that you need to go and get leave of the court in order to pursue your garnishment. And the judge is going to ask you questions like, why have you waited so long? Why is there a delay? And what efforts have you made to collect against the tenant in all of this time? And if you've said nothing, haven't done anything in the last 6 years, is it possible that the judge is going to grant leave for you to continue? Yes, maybe. Is it going to be difficult for your case? Absolutely. Now, versus somebody, a landlord that went in and said, well, I tried the garnishment process on year one, and I learned that the tenant didn't have any assets. I followed up a couple times throughout the years, learned that they didn't have any assets. But last year I learned that their mother passed away and they have an inheritance, for example, and I want to do a garnishment. And you present that evidence to the judge, and the judge is most likely going to give you leave, which means permission, to go ahead for another 6 years to commence the garnishment process. Now, what happens if there's an ongoing garnishment? So let's say you've got a $35,000 LTB, the tenant's employed, they don't make a lot of money, but they are employed, they're working part-time. After 6 years, that garnishment does expire, but what you do is you file a request to renew the garnishment for another 6-year period. And it's an automatic process with filling out some paperwork. You don't need leave from the judge. You just fill out a form and then the garnishment is granted to be renewed. But if you don't fill out that form before the garnishment expires, there's a possibility you're going to have to go through the leave process. So keep in mind that if you've never issued a garnishment before and your debt is over 6 years, you can seek leave of the court to go ahead and enforce it. If you have filed a garnishment and you're at that 6-year mark, there's a form to file to renew that garnishment to avoid the leave process. Doesn't happen too often, but there are garnishments out there where that part-time employee is a perfect example. And you want to make sure, because the courts don't remind you, you want to make sure it's in your calendar that after 6 years, you go ahead and you're going to want to renew your garnishment to keep it going. So yes, there are limitation periods, but there are also permissions that the court can grant you to continue going, continue to enforce the debt. But you had to have taken action throughout the year. You can't sit on that debt without a good excuse and expect the court to give you permission to continue. So yes, leave is possible, but be proactive in trying to collect, enforce, or otherwise get the money from the tenant so that if they do come into an inheritance lottery win, improve financial positions, you haven't forgone the right to collect. So keep that in mind. All right, we have talked about filling out the affidavit for enforcement request. You do have to do this again on renewal of your garnishment and any other enforcement request you're looking for. So again, if the tenant switches employment, you're going to have to do the 20p multiple times for every enforcement request, including renewing your garnishment. So really learn the principles of this form, learn how to complete this form. It's not the most complicated form, but there is a bit of math you have to do. And you have to make sure that you're calculating the interest charges each and every time. We'll get into that a little bit later. All right. So preparing the notice of the garnishment, the Form 20E, you first start with that Form 20P. That's the most daunting paperwork there. The 20E is just some information about yourself, information about the debtor, information about the person, the employer or bank you're garnishing, and then the final amount that was calculated from that Form 20P affidavit. They're filed together at the same time. The most daunting part about the garnishment process itself is actually the math because you have to calculate the interest provisions in each and every single payment you receive, as well as the interest provisions of the daily court rates, and those change quarterly. You can find them on the official court website, and we're going to provide a link as well. And then what you're going to be looking for is post-judgment interest because there's pre-judgment interest, which means before you got your garnishment, before you got your court order, and then there's post-judgment interest. I can tell you right now, if you're a landlord, you don't have to worry about the pre-judgment interest because the board doesn't award pre-judgment interest. It's the post-judgment interest that you're going to have to really be concerned about and calculate. Prejudgment interest is not something you get at the LTB. It is something you get in small claims court, but it's not something that the board awards at the Landlord and Tenant Board. So on your forms, prejudgment interest in almost all cases will be zero. You just have to worry about that post-judgment calculation. Filing the documents with the courthouse. When filing the documents with the courthouse, there's an online portal. We're going to include a link to it as well. And that's most likely one of the best ways to file your documents if you've given yourself enough time and confident that the forms and paperwork you have filled out are perfect. There is a disadvantage to filing online, and that is you need a commissioner because your document, your Form 20P, needs to be sworn. There's many online commissioners. They generally charge anywhere from $20 to $35. The courthouse does this for free. So if you take your paperwork into the courthouse, they will commission and file it for you. There's not that additional cost to get it commissioned. On the other hand, there is that cost and that time in traveling to the courthouse. So you have to weigh the two. The beautiful thing about being in the actual courthouse is if there's an error on your paperwork, the clerk will show you how to correct it so you can do it right there. Where if it's the online way, they're going to reject it, refund your credit card money, and then you have to refile as if it's new again. And sometimes it takes 2 or 3 times, especially if this is your first time in doing it, and you're not sure if the paperwork is correct. Therefore, it may be more wise to actually go down to the courthouse and get this notice of garnishment and the Form 20P executed and filed right then and there at the counter, and they can help you correct any errors. There's one other advantage we talked about earlier And that is the timing of these garnishments, especially when it comes to a bank garnishment. You're not going to want to serve the bank your garnishment on the second or third day of the month because that's when the tenant's going to have the lowest balance in their accounts. Presumably, they just paid rent, and presumably that rent is due on the first. It would be better to time your garnishment near the end of the month, the 28th, 29th, 30th, 31st. Processing times are dependent on the banks. Be mindful of that. Point is, if you're going to do a garnishment, it may be best to do that at the end of the month. For an employment garnishment, for an employer garnishment, that's not necessarily as important. If you know that the tenant is switching jobs, you may want to hold off because every single garnishee is another fee and is an additional step. So if you've learned that they're quitting their job at Tim Hortons or wherever they may be working and they're starting somewhere else next week, you're going to want to hold off. It doesn't make sense. You're going to want to do it to the new employer rather than the one that's being terminated relatively soon. All right, so that is again filing documents with the courts. You can go down to the courthouse and file your documents or file them online. Serving the documents. Yes, you have to serve the documents, and you're either going to serve the documents yourself or you're going to hire a process server, a friend to serve your documents. Who needs to be served? Well, the garnishee needs to be served. That is the bank, the employer, whoever you're garnishing. And they should really truly be served personally, which means you, a friend, or a process server should take the documents to the employer or the bank or whoever you're garnishing and personally deliver it to them with their name because you're going to need to swear an affidavit of service. And that affidavit of service has the place that you served, who you served, and essentially their position, as well as the address. So take diligent notes. And also how you served. A garnishment should be served personally. Technically, you could serve it by courier or registered mail with a signature, but the courts then can also reject it, especially if it's on a corporation or if the employer says, I didn't receive it. Personal service is the best in a case of a garnishment when you're serving the employer, the bank, or whoever you're garnishing. When it comes to the debtor or your tenant, you have to serve them as well. They don't need to be served personally. In fact, I would say it's a mistake to essentially serve it personally. It really has no bearing on the court whether you've served it personally or served it by regular mail. Let's say you served a bank account. Let's just take this for an example. And this is why I say it might be a mistake to serve it personally. So you go to the bank, you serve the bank the garnishment, and then you run over to the tenant's house, their new address that you found, and you served them. The bank takes some time to process that garnishment. After you serve the tenant, what do you think the tenant's doing? The tenant's going on their mobile banking account right now and they're transferring all the funds out of that bank account before the bank has even had time to process that garnishment. So is it wise to serve the tenant personally? It's up to you, but I would say not. Strategically, there's no benefit in doing that. What I always did in my practice is stick the notice of garnishment on the 5th day in the mail. That's a legal requirement. You have to serve the tenant, or what we're calling the debtor now, because the process has changed. They're no longer your tenant, they are a debtor, within 5 days after you serve the garnishee. I serve them by mail. Why do I serve them by mail? Well, I'm hoping that the garnishment is processed before they're aware. Because I don't want them to be aware before the bank goes ahead and processes the garnishment. I don't want them to clear out those funds. So yes, I do have to serve my tenant, but that doesn't mean I need to run down right away and serve them in hand. I can mail it. And that mail time I'm going to take to my advantage. Of course, after you've served them, you have to continue to do that affidavit of service. So I wouldn't just stick a stamp on it and say I served them. I would take a photo and get a receipt of that stamp. Best thing is to go down to the post office with the receipt, take a picture of the receipt and the stamps, hand it over to the clerk, and then bam, it's mailed. You've got your affidavit of service. You've completed that. You've followed the rules. You served your tenant, which we're now calling a debtor, and the garnishee is served. You take those papers, you get them commissioned. Again, this is something you have to get commissioned. So you're going to file them at the courthouse or you're going to file them online. They do need to be commissioned. Once you file them, the court accepts them and it triggers that response for if the court receives any money, hold it for 30 days and then send the payment out to you. If those affidavits of service are not in the courthouse, are not received by the court clerk, it will not trigger the action to release the money, and the money will be held until you've followed through with those affidavits of service. So make sure that you file those affidavits of service if you want to see the money that is garnished. All right. Again, completing the affidavit of service, we went through that. It is the Form 8A. It's something you get from the Ontario Court Forms website, and it is a must. You must complete the affidavit of service for everybody you served. All right, so then the garnishee, as we discussed, they pay money into the court. How do they do that? Well, that's through your garnishee statement. That's that form that you've partially filled out that you've handed to the bank or the employer, and then they're going to take that with the money and send it to the courthouse. It's not wrong to follow up with the garnishee if it's a bank or the employer, give them a call or go down and say, hey, have you processed my garnishment yet? It's not wrong of you to do that by any means. You're the creditor, you have a right to know. Now, let's say they didn't process it. They have an obligation to notify you why the garnishment isn't processed, and that's part of the garnishee form. So they can fill it out and they have an option. I don't owe the money because, and they give a reason. And maybe that's because the tenant no longer works there anymore. That's a common one. Or there's no money in the bank account to be had. That's another unfortunate one that happens. But the garnishee is supposed to notify you. In my experience, they don't. They just send that paperwork to the courthouse, and then the courthouse unfortunately, never actually notifies you of where that is. You call down to the courthouse and go, has any money been paid in? And they say no. And you're left wondering why. Follow up. It's not inappropriate to follow up with the bank or the employer and find out why. Why haven't they sent in the money? It's also good evidence if they're negligent or just not following the rules. Because if they say, I don't know, or they hang up, or there's an excuse, you use that in your garnishment hearing to go, you know what? I tried to communicate with them. They've ignored me, and that's why we're here today, Your Honor. I want a judgment against them. So following up is not just good to see where your garnishment is, but it's also good evidence in case the garnishee is not going to follow the law and do their responsibility. It is not harassment when you follow up appropriately. So keep that in mind. All right, the garnishment duration. We've talked about this one and we're going to mention it again. It's good and it's valid for 6 years. What does that ultimately mean? Well, if they're employed, you're going to be garnished for 6 years. If they have a bank account, that's a little bit different. So technically, any money going into that bank account is supposed to be garnished and sent to the courts, but the banks often do this only one time. And the tenant, generally speaking, only makes the mistake of putting money into that account one time and then forces you to find the bank account again. So for that 6-year duration of that garnishment, yeah, technically it applies to the employer and the bank accounts. In my experience, pay more attention to the one on the employer than the one on the bank account. Because once the tenant has had that bank account garnished once, the likelihood of depositing more money into that bank account is slim to none. All right. And again, we talked about the renewal, your 20-point E1, which you need to do before the garnishment expires. So if you have that employer garnishment that they're working part-time and it's taking a long time to pay down because it's only 20% of the wages and you have a massive debt, you need to record when that garnishment expires. The courts are not going to call you and say, hey, the garnishment's expiring next week, get your paperwork in. It doesn't work like that. They leave it, it expires, and you wonder why the money stops flowing in. You go to the courthouse and they say, oh, it expired. But now it's over 6 years, and you have to get leave and permission from the court to continue that process. So keep it in mind, 6 years is an important date. All right, buying the debt. This isn't necessarily for you. More for your collection agencies and some of your legal firms that are going to go ahead and purchase debts and things like that. You understand that there is a termination of the garnishment. And that termination of the garnishment happens when it's satisfied or, it's been bought out, for example, or maybe the tenant paid you in another way. Maybe the tenant, because they're trying to buy a house or something, the mortgage agent says you have to pay this off. And instead of paying it in court, the tenant contacts you and it's paid off. And that has happened. Your obligation is to ensure that there's a termination of that garnishment so the employer, the bank doesn't continue to keep paying. It is your obligation as you file the garnishment to take that garnishment off. So do be clear that you have an obligation once the debt is satisfied in full to file this little simple form that says, please don't garnish anymore. All right. And yes, there are consequences in not completing that form that the tenant, your now debtor, can pursue against you, including court costs. So just make sure that when the garnishment's paid in full for early or for whatever reason, you just file the form to make it stop. So, yes, many of the documents do in fact need to be signed. And I get the question about signature a lot is, does it have to be wet signature? Can it be electronic signature or can it be typed in? Courts, the higher courts have said it doesn't matter if it is a wet signature being ink on paper, digital signature being electronic way, or your handheld just typed in by your computer. That doesn't matter how your forms are signed. It is a requirement that they are in fact signed, even if that's a print signature. Courts, motions. Motions to court can come from the garnishment hearing essentially, but as well as that motion to leave for some sort of permission. There can be other motions to court brought as well. Maybe the debtor had a change in circumstances and can't afford it anymore. Do they file a motion to vary garnishment? Technically, that's allowed. So anytime during the process, you could be served with a motion from the courts. Doesn't happen very often, but do be advised that it's a process that the debtor and interested party can do, and you'll have an obligation to respond. We're not going to get into the response of a motion today. It rarely ever happens, especially beyond the garnishment hearing process. Because a lot of court clerks, let's say the debtor goes in and tries to dispute it now, and it's past the time, the court clerk doesn't bring up the motion issue. The court clerk says, I'm sorry, it's past the time to file the garnishment hearing, because there's only so long to do that. They have to essentially go to legal aid to go, oh, well, we can try a motion. The clerk generally doesn't provide that advice because it borderlines on legal advice. They just say, oh, time to file is this. I can't give you the form because it's past that. So it doesn't happen very often. Rarely does it actually happen that you're going to go to court for a motion. We're going to bypass this a little bit here because it just doesn't happen that often. Pay more attention to the garnishment hearing. That makes sense. All right. Are there fees? Oh, yeah, there are fees. But the cost of this recording here, your garnishment hearing should be on or about $136 for each and every single garnishment you process. Additionally, there may be some fees for process servers and then any other additional fees that you receive for commissioning. The biggest fee in enforcement process often comes from something called skip tracing, and that is not paid to the courts. That's paid to a third party private investigator or skip tracer that goes out and attempts to find what you can garnish or the assets to seize. And that's generally speaking the most expensive cost. So what kind of costs are you looking at in this process? I've seen 500, I've seen 1,000, I've seen a little more, I've seen a little less. Where can you save the fees? You can save the fees from the labor of hiring legal representatives and hiring PIs and stuff like that, because you can't vary the court fees. Those court fees are pretty much set. Where you can is doing some legwork and attempting to find the tenant or filling out the documents and the forms yourself. That's where you can save most of these fees. But yes, there are fees involved for filing the garnishment you need to be aware of. It's not free to go down to the courthouse, have your debit card or some cash ready to be able to file. Preferably debit cards. The court seems to love electronic over cash. All right. Oh, before we go on any further, can you get the fees back? We should talk about that. Are they recoverable? In the enforcement process itself, the direct fees that you pay to the courthouse, like issuing the notice of garnishment, can be and is recoverable on your Form 20P affidavit of enforcement request. But your other fees, like to your legal representative or to your skip tracer, are not over the counter enforceable, which means you can't add them. They're not approved over the counter. You would need to file or have some sort of leave of the court. And you generally wouldn't do that unless you attend a hearing, like an examination hearing where you can get fees, a garnishment hearing where you can ask for fees, but over the counter stuff and getting help from the skip tracers and the paralegals, generally, without going to one of those hearings, you cannot get. And even at one of those hearings, it's going to be up to the judge. So fees in this process, unless they're the court forms, are rather rare. They do happen, but they're rather rare. What you are going to find, though, is the fees that you pay out to the courthouse are automatically calculated into the form when you fill it out. So make sure you keep track of every garnishment that you've paid for, add them up, add them to the bottom of the Form 20P, and file it with the courthouse. All right. Whose responsibility is to pay the garnishment? Essentially, we just discussed that. You're paying for that out of pocket, and then it's going to be added to the amount of money that the tenant is going to ultimately be paying you when you successfully garnish your debt. All right. Timeline for payments. Well, the garnishee is required to send the funds into court within 10 days. But once it's at the courthouse beyond that 30-day hold, there's no rules in the court level that says you must be paid out by a certain day or the government is going to be held liable. That's not how it works. So yes, there's a timeline that the garnishee needs to send the money into the courthouse, but there's no timeline on how long that money is going to go from the courthouse to being sent to you. We do know to expect to wait more than 30 days for the first garnishment check itself. All right. Regulatory framework, again, here you're going to see some rules in the rules of the small claims court as well. Some other acts you can take a look at is the Execution Act. That talks about what can be garnished and what can't be garnished, and additions to the Wages Act. Take a look at the Wages Act. That's where you get the 80% exempt from garnishment. So you're going to look at the rules of the small claims court. You're going to look at the Wages Act. You're going to look at the Execution Act. Be familiar with those three. They're the ones that are going to come up the most. Read the rules for payouts on garnishments. Different types of debts. You're a standard creditor in this province. Ultimately, you have no special holdings. But let's talk about this for just a minute because it is kind of interesting. So because you're an ordinary creditor, you really truly don't have any special provisions. FRO, Family Responsibilities Office, they do. That's enforcing against child support and spousal support and things like that. Their garnishment amounts are a little bit higher. And there are some other ones. For instance, the Repair, Storage, and Lien Act. So if you are a mechanic and you have put a writ or a sale or seizure on some sort of vehicle, for instance, and you've also have a writ of execution or maybe a garnishment or something to enforce. That vehicle is sold if it goes into the bank account and there's a writ of sale and seizure attached. They get the money first. They're a priority lien claimant. So keep that in mind. And it really doesn't happen. But you're an ordinary creditor, and there are some preferred creditors under statute law that would get the money first. Not the fairest system out there, but it is the rules we have to follow. Not right. Yes, we know that we can dispute garnishments. We've talked about disputing garnishments. We're going to skip over this one here. Yes. Just as you have to serve, you need to be served. So there's no trial by ambush here. And the courts won't allow something to proceed if a party isn't present and wasn't properly served. So if there is a garnishment hearing coming down, you shouldn't have to worry about calling the courthouse every day and going, oh my goodness, is there one? Is there one? Is there one? Did my tenant file? Oh, you need to be served. You need to be notified. There's no trial by ambush here. There's no mysterious trials that are going to happen without your knowledge. So just as you have to make service, they have to make service. You do, though, require to make sure that your address is updated with the courthouse and, in fact, accurate for service. Because if they mail something out and your address on file with the court isn't accurate, and the judge sees that it's been mailed out, they may proceed without you. So do keep in mind that it is your obligation upon a move or whatever to notify the courthouse if your address for service has changed. All right. Again, standard rules. Keep an eye on these ones. Rules of the small claims court. You can go through it at your own leisure. There are some rules in the garnishment section, but most of what we have talked about, we've covered them today. They're rather basic rules. There's nothing incredibly special as far as garnishments are concerned. And again, it's a more simplified process and truly more simplified process than the LTB is. Okay, again, we've talked about the conditions and different things of lowering payments. Essentially, the tenant can file a garnishment hearing and plead their case why the garnishment should be less. And if they have some proof, it's possible that the judge is going to go ahead and lower those garnishment payments. Is it likely? They need some incredible proof. Is it possible? Yes. Is it likely? Maybe if they have some proof. Is it forever? No, there'll be some stipulations of what the judge orders. So do keep that in mind that yes, the payments can be lowered, but the tenant, what we're calling the debtor now, is going to need some proof of those and take some action. Rarely do I find the debtor slash tenant ever actually take some action unless they're on top of things, and that's rather rare. Most cases, they ignore it. Unfortunate situations is sometimes they just quit their job altogether. I have seen these almost vengeance style situations. It happens primarily when they're working in the customer service industry or jobs that have typically have high turnover. They're getting garnished. They may actually quit their job and go work for somewhere else. So keep that in mind. These vengeance type actions do sometimes happen. All right. The garnishment hearing again, we've talked about it. It's for the parties to settle some disputes and the tenant to verify the garnish or vary the payments of garnishment. One we haven't gone into too much here, and we're going to get to a minute, is co-ownership of debt. And there are some rules on that. So any interested party, co-owner of a debt, etc., can file a request a hearing. All right. Again, we skip this and we're going to get down to the co-owner of debt. So, garnishment hearings, co-owners of debts, and other things. Really interesting, rather, here. If you have the co-owner of debt situation, which sometimes garnishment hearings come up, or if you're a creditor and or a debtor, they can be verified. Perhaps one debtor owes or is believed to owe a little bit more than the other one. They can plead their cases, but in Ontario, if you have a judgment against the tenants, they're joint and severally liable. So it doesn't matter if one tenant comes in, and let's use this example. It was a husband and a wife situation. They were both of your tenants. The husband has a great job. He paid half of his rent. He constantly paid it. The wife didn't work, or vice versa. It doesn't really matter. But one of the spouses didn't work, the other spouse did work, and you take them to a garnishment hearing. The one spouse can't go, you know what, I'm not responsible because I've already paid half of it. No, they're joint and severally liable, which means you can go after whoever is on that judgment, whoever's working at the time, whoever's owed. They can, again, they can file, they can make a claim, they can make an argument at the court, but the defense of, oh, I paid half the debt or I don't owe this isn't going to work at this level here. In a garnishment hearing, it's unlikely the judge is going to say, you know what, you don't owe it all because you're right, you paid it. It really truly doesn't matter. Joint and several liability means you go after the one with the job, without the job. You're both equally responsible for making those payments. All right. So co-ownership of debt, again, a little bit different. And this one is a little bit different here, where let's say it's you and your business partner, you have the debt, you own the debt. 50% of the indebtedness can be garnished in this particular situation. And again, it's one of those situations where it doesn't come up too often, and it really, truly just does not. But every once in a while it will. More commonly than not, you'll essentially see this in legitimate divorces and divorces that are in fact happening. Sometimes it's settled out, sometimes they're not. All right. I don't know how far we have to go in through these ones here at this point in time.
Mm-hmm.
They're rather rare.
Yeah, we can skip that. That's the case. The co-owner, special cases and garnishment.
Oh, that's about it. But I feel like we shouldn't just finish it off with co-owners of debt here.
Maybe
Good
you can
boy.
just like browse through it. Just give us like the Cole's notes on what it is. What is a, well, you already went through co-ownership. I think we
Yeah,
can skip this part. Let's keep going and then we'll cut this part out.
I don't think we have anything else. That's the
What are
sad
these
part.
special cases? Why don't you go through special cases?
Special cases actually really truly don't actually apply to these
Oh,
in
okay.
most all of these situations here.
I have some questions when you were talking through it. You know the 6 years thing, right? So say for
Yeah,
example, someone has reached 6 years. What should they be filing that form that you were talking about to renew?
yes, they should be filing that to renew that. Absolutely. If it's still ongoing, if the garnishment's still ongoing, if it hasn't been resolved, they should file it, or they're just going to dry up and then you need to leave.
What if it's not about garnishment? What if it's just regularly enforcement? You
Oh,
know,
any
like,
type of enforcement. Yes, you can
okay,
file a
any,
motion to extend that time. Actually, that's a great question. So, yes, it doesn't matter just about the
yeah,
garnishment itself, but essentially any form of enforcement except for the examination hearings, you can file a writ for. And this is typically when you're going to go and put in the writ of sale and seizure of personal property, writ of sale and seizure of land, or the garnishment itself. You can file a motion to ask for leave and permission. Where this most
okay,
likely happens, wedding, is when let's say the tenant is came into some sort of inheritance or something, you would file your motion and your examination hearing essentially at the same time. You would ask
mhm,
for your motion to allow for enforcement and your examination hearing to find out where that inheritance money was deposited. Was it,
okay,
is it still in the estate trustee? Is it in the estate account? Has it gone into a bank account? Is it in probate? Where is it? So, it
okay,
happens to get information that the parent died, whoever died, aunt died, it doesn't really matter, that they're getting an inheritance
yeah,
and the landlord gets wind of that they're getting a inheritance, they're going to and let's say it's been over 6 years, it's been 7 years, 8 years, or 9 years, you're going to do the examination hearing and you're going to
mhm,
file your motion and you want them at the same time. So
okay,
then you got your examination hearing, they've admitted that there's assets there now, and then you're going to get the permission from the court right away so you can go down to the counter and fill out the enforcement, whatever it may be you're going to do.
okay, understood. Gotcha, because there are cases where people with LTB orders and they're reaching that 6 year mark. So that means that I can't send it into send it into Equifax. But technically, if they went to small claims court and tried different things, then that means that they've got 6 years to report into Equifax. And at that 6th year, they should do a renewal.
Yeah,
But
they
in
should
order,
get.
but then from a LTB to small claims court, that is 2 years limitation to get it enforced.
To, yeah, so this one continues to come up. To file your from the LTB to your certificate of judgment, I keep hearing that you have the 2 year limitation period to do that. I haven't found a authority in law that says, okay, you must or have to do that. But from my experience, what they're
Mhm.
doing is they're sending back after the 2 years because the standard statutory limitation period is out, is the clerks are sending back a motion form. Because go file a motion so I can accept this. The same as getting it renewed, essentially.
Really? What is the certificate of judgment versus the examination hearing versus garnishment?
The
What does that
certificate
do?
of the certificate of judgment is literally just they don't even hand them out anymore. But it's just a
Like, what's that?
certificate that says yes, this is what they owe. Proof of the judgment, essentially.
So
Um,
everybody should actually go and do that?
no, 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 no. But you have to do that if you want to get to the next steps at small claims court. You have to take your LTB order, and when you file it with the courthouse, you have to pay that certificate of judgment fee.
Did we do that? You and I, we went to do an examination hearing, but did that?
You switch it over, yeah. It's an automatic. It's just an automatic fee added. We don't
Oh,
hand out.
they already did it then. They
Yeah.
then if we did an examination hearing, then the certificate of judgment was already included, is what you're saying. I
Yes,
see, I
exactly.
see, I understand. But if people don't do an examination hearing, don't do garnishment, then they would go get a certificate of judgment.
Yeah, essentially, if they don't do any enforcement whatsoever, they're going to pay
Yeah,
to register it with the courthouse, and they're not actually
just
getting a
register.
certificate back. That's the
Yeah,
best part. They're just paying a fee to register it with the small claims court.
that is
Um,
crazy. Like
you
this
get a
whole
file.
thing is like freaking crazy. Like, uh yeah, Jordan, you know what's funny? Here, I think this is good to go, okay? We're good to go on the rest. Thank you so much for tuning in today. I hope you've learned at least one new concept. Please consider subscribing or giving us a thumbs up so we keep sharing high-quality educational courses on Openroom University. Check out our other videos to make sure you stay informed. If you've got feedback or just general ideas for my team at Openroom.ca, please send it to us at hello@openroom.ca. Cheers to a transparent and connected rental ecosystem.